Słychać mnie? O, dziękuję.
Good evening, ladies and gentlemen. Ireneusz Kamiński. I'm the director of the Center for Dialogue and Understanding. I would like to welcome you at this public debate. I would like to welcome everyone who has come in person and everyone who's watching us online, and also those of you who will be watching it afterwards. We were supposed to meet at a panel about international law, but devoted to a different topic, because we wanted to talk about Mr. Putin's decision about the recognition of these strange entities in the east of Ukraine called People's Republics. But the reality actually changed everything, because a few days later, in the morning of the 24th of February, President Putin decided that Ukraine is not worth of its sovereignty, that the Ukrainian people do not have a right to independently decide about their own territory and their own country, and the Ukrainians do not deserve it to be treated as a separate country, separate entity. And our center has condemned this act of contemporary barbarian kind of actions. The Polish-Russian dialogue under these conditions needs to be built upon something that is contrary to what Mr. Putin represents. So we should build relations with these Russians who can accept that the right to sovereignty, that the right to your own fate is just a part of everyday and contemporary world. And this is the kind of right that all our neighbors should enjoy. You can see that I have mentioned a few legal terms stemming from the international law, but this is a very important topic. We should analyze it with the participation of experts. We will not be talking about these republics in the East. We will be talking about the attack on Ukraine and what it means from the perspective of international law. Łukasz Adamski, my deputy in the center, will conduct the debate, moderate the debate. Good evening, ladies and gentlemen. Before I introduce our panelists, before I make an introduction, I have one housekeeping announcement. This debate is available on our YouTube channel. It's available also on Facebook. It's simultaneously interpreted both into English and Ukrainian. I hope that you understand the symbolism and the gravity of the situation. And I would like to say at the very beginning a few words to our allies, Ukrainian friends who watch us in Ukrainian.
Do naszych ukraińskich друзів, bo
Now, the war that Ukraine is right now involved in, and Ukraine is right now defending itself. And this war is important for all of us. Because in this war is about fundamental principles of international law. This is the war about the rule of law and about our values. And what should regulate international relations between various countries? Should it be force? Should it be maybe norms and principles? So this is why we should talk about the tools that Ukraine has at its disposal and the world has at its disposal. What can we do from the perspective of international law? We should also talk about the responsibility of perpetrators, of those who are responsible for this war. And it is about this war and the tools of international law we would like to talk today. What can Poland and other civilized nations can do in this current situation? Now, we will be talking with two experts, eminent experts who have been working with us for many years. Professor Władysław Czapliński and Professor Ireneusz Kamiński. Now, if I would like to introduce them, I would have to enumerate quite a long list of bodies that they used to belong to. I will just mention that there were many of such bodies and institutions, but they mainly work at the Institute of Legal Studies of the Polish Center for Science. Mr. Czapliński, this is the Higher School of Law and Administration, and for Mr. Kamiński, it's the Jagiellonian University. Thank you for accepting our invitation. And at the very beginning, I would like to ask you firstly for a brief introduction. Could you tell us what is happening? Because there are some basic questions that lawyers maybe understand, but the general public not the crime against peace, war crimes, etc. How should we qualify Russia's actions? Which international institutions can intervene? What does it mean? What has recently been done by the chief prosecutor of the International Crime Court? So please, very briefly, an introduction, and then we'll have more detailed questions about the way in which we could deal with this conflict. I will give the floor to Professor Czapliński first. Thank you very much. Ladies and gentlemen, I am very happy to see you today. Albeit, I'm very sorry that we are meeting on such an occasion. What happened 1 week ago has turned the international legal order upside down. And the world will never be the same again. It has changed, and it changed on the 20th of February 2022. Almost 8 years ago, together with my colleagues from the center, we were discussing the annexation of the Crimean Peninsula by the Russian Federation. And we thought at that time that it's unbelievable in the current civilized world that such things should not happen, that the international community has been building the system of collective security exactly for the purpose of such things never to happen again. However, it turned out that life extends beyond our imagination. A few days ago, before the Russian aggression, it seemed impossible. It seemed impossible, such a wide-scale military intervention in the 21st century. Our imagination did not reach that far. And in fact, there are two things that we should discuss. About two things that should not happen in Europe in the 21st century. So the first question is, what should we do to stop this war, these military actions? And I think this is connected with many interesting aspects. And secondly, what are the legal consequences of what has happened? And I mean both consequences for the relations between Russia and Ukraine, and what Russia and what Ukraine do we mean, but also what does it mean for the relations between Ukraine and the outside world and Russia and the external world. I have been dealing with a theory of international law my whole life. It just happened to be like that. I have never worked as an advocate. I have never been an international officer. I have never been a judge on any international court. So probably my perspective differs significantly from the perspective of many of those who practice law. But I do hope that we will reach a consensus when it comes to how theory can be applied in practice in this case. Thank you so much. Very briefly, from my side as well, just a few comments, because part of history has ended, and it lasted 30 years. This is the kind of history that we got used to, and we thought it would remain like that forever. It started changing at some point. And this important breakthrough, this warning, was the annexation of the Crimea. And Professor Czapliński said that at that time, it seemed unbelievable. And, you know, in Europe, it should not happen because one country just infringing on the territorial integrity of another country, this should not happen, but it did. And right now, yet another incredible thing has been happening. And we are lawyers, and we try to take a legal perspective of that. Now, Cicero said that laws are silent during a war. And that's true. Laws were silent for a long time during many wars, but a certain change has happened. And Professor Czapliński mentioned that as well, namely an international community has been created. International organizations were founded. So therefore, we have a certain bond. There is some kind of attachment to certain very important legal principles. And it's not that Ukraine is defenseless, that Europe and the world cannot defend themselves. If you follow the events from the legal perspective, because we are looking mainly at what is actually happening in Ukraine. But you might have also noticed something else, because the media has been commenting on that. What is happening in legal terms? Well, a lot is happening. Yesterday, a very important resolution was adopted by the General Assembly of the UN under the Uniting for Peace procedure. Such a procedure has only been triggered a few times in history. And the result of the voting was incredible, because only 5 countries, including Russia, were against the resolution. And this resolution clearly said that this is an aggression, that this is the infringement of fundamental legal principles and of the principles of the political and legal order. The United Nations has started working. Also, the International Court of Justice, that is a court at the UN, at the beginning of the next week, that is also under a very urgent procedure. So an investigation will open next week. There will be 2 sessions because of Ukraine's complaint that was lodged against Russia. And yesterday, late in the evening in The Hague, in the ICC, a decision was made to trigger a procedure before the International Criminal Court. And this is the court that deals with, for example, with genocide, with crimes against humanity and war crimes. And finally, we have the European Court of Human Rights. There is a new Ukraine's complaint against Russia. And a quick reaction is there as well. There are interim measures adopted by this court, which obliges Russia to undertake certain actions. And these actions should mainly aim at protecting civilians. So we can say that all available international procedures have been triggered. And this is something that we will talk in more detail, I think. So this is my preliminary comment. So there is a very quick reaction before all available international bodies. Thank you. I have two questions after listening to your remarks. If this war is illegal, war as a tool of international politics was delegalized in 1929. Briand-Kellogg Pact. So Russia has been waging an illegal war. So the question is how to finish the conflict, how to end it. Because usually after a war, a peace agreement was signed. Before that was a ceasefire. But at what price? Maybe certain concessions, because if Putin's exercising the politics of the 19th century, he might demand the territorial cessation. And this is the question to Professor Czapliński. Will that be legal at all? And another question to Professor Kamiński. What does this resolution adopted by the UN mean? This resolution, United for Peace. We know that the Security Council did not make any binding decision. And the reason for that is that Russia vetoed that. But in the UN Charter, you can find Article 27, which orders the party which is involved in the conflict not to vote. Why wasn't this article applied? What are other legal tools available to other countries? Can we legally help Ukraine, for example? Maybe also military, help them military.
Przepraszam, ja tutaj muszę...
Sorry, I have to take notes because Łukasz asks so many interesting questions that I can hardly follow them. But let me start with the following. You've mentioned that Briand-Kellogg Pact delegalized the war. That's the case, indeed. However, at the same time, still, during the period between the wars, the countries were trying to pass by the territory of the war. They came up with the whole range of notions, a special military operation, for instance. But from the perspective of the UN chart, the legal tool for the international community, it is forbidden to use any force, any, besides the situations that clearly stems from the UN Charter. And there are 3 exceptions. None of them can be applied to the current situation. There is yet another question, namely the question of the custom law. In the international relations, the custom law is treated really seriously, and it has exactly the same position as international agreements. We are used to the national law, written law. This is the basis. So if something is not actually written in the Journal of Laws, then in fact we have a lot of doubts whether it's really applicable. But it's not the case for the international relations. So independently from the UN Charter ban of force relating from the Charter, the same ban on force was actually formulated under common law. So the International Court of Justice that was actually thinking about it when the U.S. Acted in Nicaragua, they said the content of the common law is exactly the same as the content of the UN Charter. You cannot use any force against another state. Answering the question about the peace treaty. The peace treaties are the legal instruments of a very specific nature, very unique nature. Because if you look at the history of the peace treaties, they are not equal. To a certain extent, they have been the dictate of the winners. So the question now is how far the state actually, who is losing the war, who is defeated, to step down. Because the peace treaty, this is the kind of agreement between the winners and the losers. I know that it does not seem to be politically correct, but this is the reality. Now, the territorial assignment under the peace treaty, would it be legal? On the one hand, we may say the peace treaty was, in a certain sense, enforced. So usually the country who is defeated has to cease the military actions because it's no longer able to continue war. So we don't know whether Ukraine could give up on and what Ukraine could give up on. So we may say the first thing Ukraine should do is actually to separate the Lugansk and Donetsk region, give up on these territories in benefit to whoever, and actually then they should build a border along the occupied territories, these so-called People's Republics, and call for the UN Peace Corps, or EU Peace Corps. Ukraine has not done it. That's why we now have to confront much more serious situation. So we may say, on the other hand, that this assignment treaty of these territories occupied by Russia, this is the agreement which was enforced as a result of the force applied by the occupiers. And the international law says that international agreements enforced by force are absolutely illegal, and they should be made null and void. However, I don't remember whether actually any of the recent peace treaties, whether they have been actually based on the Treaty of Paris and Vienna Convention. I'm not sure whether we should discuss it today. We don't know actually what will happen tomorrow, the day after tomorrow, what will be the situation like, because this will definitely impact the legal solutions that will constitute the basis for the peace talks. It's like trying to foresee the future, but I hope that there will not be the situation where Ukraine will have to give up on a part of their territory. Ladies and gentlemen, answering this question, the detailed question that Mr. Chairman asked about this specific procedure which entailed the resolution of yesterday. I was trying actually to find this resolution. I was not able to find it, but actually what I said before, my comments were not based actually on the content of this resolution, only about the information, what is contained in the resolution. So we face the infringement of the international peace, aggression of Russia, and participation of another country, Belarus, in the act of aggression. So the details of the resolution, for that we still have to wait a while. However, to give you some legal context that is very important from the practical perspective, namely Russia vetoed the resolution of the Security Council. This is the resolution of the Security Council, which is a binding document. So Russia disabled the creation, development of the binding legal act. The case of this specific procedure, well, if in the critical situation it is not possible to undertake legal action, this case, therefore, ended up in the UN General Assembly meeting. That's interesting. The first resolution as of 1951 indicated actually the possibility for this procedure, how it was described by the General Assembly. This area was precisely described. It is infringement of law, of peace, and aggression. So, ladies and gentlemen, it's not a procedure that would be applied in any case of infringement of integrity. This is about the critical cases. It applies to these critical 3 cases. And bear in mind, please, that this is not a binding document, but even though it's critical, it's very important because it specifies the position of the international community. That's why it also indicates the qualification of actions in a unanimous way, in a very firm way. And this will stay with us. It will be important in the context that was mentioned by Professor Czapliński. Ukraine enters into peace agreement in a situation of a critical infringement of international law. It will, or it should actually, shed a light to the hypothetical treaty that Ukraine would hypothetically be ready to sign, allowing for certain concessions. Therefore, the resolution of yesterday is really strong. However, it does not need to be the only voice of international community. Maybe it will be followed by another ones as a consequence of these strong formulations and qualifications that were contained in the resolution. So it can be just the beginning of a certain activity under the UN actions. Unfortunately, at the level of the Security Council, this will not be, we will not see this unanimity because it will be, decisions will be vetoed by Russia. There is this kind of legal context within which the UN is acting. But what happened, that was the attempt of the international community to react to specific critical infringement of international law, and we succeeded yesterday. Just a short comment. I don't want to trigger a legal dispute here. However, Professor Kamiński mentioned one important thing in the beginning. You came up with the same idea. We started a day, actually, looking for the content and text of the resolution. No lawyer would talk about a given document without reading it. And formulations or notions used in this resolution could be a precise and precious indication how the General Assembly would like to understand this resolution, because the history of United for Peace, this was a resolution that was developed under Korean War. It was about withdrawal of Soviet Union from the meetings of the Security Council, because the Security Council has to actually meet in the full composition. They had to find a way to solve the problem of lack of presence of Soviet Union. So United for Peace is a unique resolution, is a unique formula, but I would risk saying that resolution under United for Peace formula are as firm, as important. They have the similar legal significance as the resolutions of the Security Council. You mentioned Belarus. So letting the aggressor actually into their territory, Belarus should be held equally accountable for these crimes as Russia. Can Ukraine legally actually enter their troops to Belarus to self-defend themselves? That was my conclusion, but I would actually be happy to hear the opinion of experts. And yet another thing, we said that Ukraine potentially could give up on Crimea and build a wall border. But under the UN Charter, there is a kind of notion like special territories of ex-colonies that the states handed over to the UN for their management, but it can be actually handed over in a voluntary way. So these trust territories by UN, maybe occupied Donbas and Crimea, could be actually treated as trust territories to be managed by United Nations. Would it be possible or not? Now, first, the question of Belarus. Making the territory available. I'm not even talking about participation of the military troops, actually, because this has not yet been confirmed as much as I know, but just, making your territory available to the others to be used for the military attack against another nation, another state, this is equal to participation in this military attack. Yet another thing that I would like to mention, aggression and military attack. These are two different separate notions that can be found in the UN Charter, and we have to be precise talking about them. Being trivial, each and every military armed attack is aggression. Not all aggressions will be an military or armed attack. So we have to assess the scope of use of force, the scope of the armed attack. We have to define it properly. I remember a few days ago, our colleagues from the Institute of the International Affairs, they were quoting President Joe Biden about the participation of armed forces. President Biden actually, he actually used their legal advisors. If there is an armed attack, the response to this armed attack must be proportional. And of course, that there could be like the cross-border shooting. The famous case. By the way, I like the historical analogies. When the warriors of Iran seized the American embassy and they took hostages, American hostages, Americans sent their helicopters in order to free the hostages. The helicopters actually disappeared in the desert. They had to send another helicopters to find the first one. So that was quite a big American scandal back then. And the Soviet judge that was actually a judge in The Hague back then, he assumed a function of the advocate of Iran. Iran was not a party to this case, and they said it was a great aggression of the U.S. And what Washington said, it was incursion. That was actually President Biden said, minor incursion. That's what he said. But an armed attack by Ukraine can justify the response. Sorry, the armed attack by Belarus justifies the response of Ukraine. But this response under the system of UN acts in the following way. When a given country is under attack, first and foremost, they can use force for self-defense. And second of all, they have to announce in the UN that it has been attacked. And then it can use force for self-defense as long as the UN, and specifically the Security Council, undertakes a decision relating to next steps. So I would say what Ukraine can do now. They can throw the Belarusian troops to the borderline and stop there. So Ukraine is not allowed to trespass the Belarusian territory. It would be actually used as the infringement of self-defense.
Now, when it comes to these trusts, they were created for completely different purposes. I cannot really imagine how that would work. But we could have a different institution, the international management of territories. And this happens in the world today. This international management was established for Kosovo, for example. This is the historically closest example. And the free city of Gdańsk, of course. This is closer in terms of territory to us. Now, the problem is that for that to happen, all interested countries need to give consent. And the Russians took over the Crimea not in order to withdraw from it now and to have it managed by the international community. And even if that happens, that Russia loses the war, Ukraine will not have any interest in establishing this international management. Now, very briefly, on my side, let us look at this definition of aggression. It is a well-established definition. It says that giving the territory for a different country in order to conduct an aggressive act is an aggression act itself. This is what Belarus did. We are not sure, we do not have any data confirming the fact that Belarusian army has crossed the border. However, giving the territory to Russia is enough. It suffices to qualify it as aggression. And let me reiterate, we do not know the content of the resolution from yesterday. We only know the interpretations. But we already know that Belarus has been mentioned in the context of the aggression on Ukraine. So it's not only Russia that is mentioned in this context. Okay, so let us just imagine. You can end a war in three ways. The first one is just a civil war, and everyone dies. No one wants that. The second scenario is kind of a political agreement between Russia and Ukraine. What I have mentioned, maybe a ceasefire, peace. We were talking about these legal doubts surrounding the question whether this peace agreement concluded under force will be valid. And the third option is a change of regime in Russia. And this is a way that could lead to the withdrawal of Russian forces. Now, a change of regime could mean that Russia would agree to cooperate with the international community when it comes to giving away the perpetrators of this horrendous crime. Now, let us imagine that Lavrov, Shoigu, Putin, and other people, Medvedev, who participated in the Security Council's meeting of Russia on the 21st of February 2022, these people who decided that Russia shall recognize the independence of these people's republics created in Donbas, in the eastern of Ukraine, and these people probably agreed to the use of force. So let us just imagine that these Russian leaders are indicted, just like some leaders from the Third Reich did. How would this procedure look like? What would be the charges? And what proof would we need? This is the question to both of you, but maybe firstly I would like to give the floor to Professor Kamiński, because he used to be an ad hoc judge in the court in Strasbourg. You have vast experience in the judiciary when it comes to human rights. The floor is yours. Now, firstly, when it comes to criminal liability, this is a very special area, and human rights is a much softer thing. But criminal liability, as the name suggests, this is the kind of a special liability, because we're talking about crimes, we're talking about punishment, we're talking about deprivation of freedom. Now, in this context, these will be special crimes. It is qualified as a crime of international law. This is a very special category. And it's not that this kind of crime and this kind of liability is only specified in international provisions. So mainly in the case law of the ICC. This crime has also been defined as leading to liability in national law. Just look at the Russian criminal code, and you will find there liability for aggression, for crime against peace, for crimes against humanity. So it does not necessarily have to be at an international level. So this liability of key leaders would not necessarily have to face international courts, not necessarily. Now, countries themselves can hold these people liable. Now, you might ask, how is that possible for Shoigu, Putin to be charged in Russia? It's unimaginable. Well, it's unimaginable today, but maybe not tomorrow, but the day after tomorrow? Why not? Of course, I mean that in symbolic terms. But really, something that looked impossible translates into certain practice. Now, on the international level, one president of one African country seemed to be safe when it comes to the prosecution by the ICC, but he lost power. He has still not been heard in The Hague, but his situation has changed, and that's this coincidence. This is where law and politics coincide. Something that happens in politics can overlap with certain legal aspects, and these key political players may be different, and it's not necessarily international courts that have to hold them liable. It is possible, but not necessarily, because it is possible on the grounds of the national law. Of course, if such people get this chance to face any of these courts, because often they do not have the chance. Well, in this final judgment, they will have to face their liability. Well, this is a different kind of liability, definitely. I just would like to add one thing. Because we use certain terms interchangeably, and these terms actually differ. And let me just quickly get back to the difference between an aggression and an armed attack, because it's really not the same. For example, because of the consequences, if you have an armed attack, it means that it is possible that the conquered country will use power. Now, in the case of aggression, no. If we talk about an act of aggression, then this attacked country needs to ask the Security Council, and under the UN Charter, the only body that can confirm that there was an act of aggression is the Security Council, and the permanent members have this right to veto. We have to bear that in mind all the time. Now, when there was a discussion about supplementing the statute of the ICC, when this statute was adopted in Rome, one international crime was not defined. Now, this crime of aggression. If participants of the conference started to try to work out a definition of an aggression, the statute would not have been adopted, probably. And everybody knew that. And it was just left aside for 10 years. And for these 10 years, and there was this additional conference in 2010, there was another important dispute taking place with the International Criminal Court. If there is this crime of aggression defined in its statute, will the ICC be able to state itself that this crime took place? Or maybe the ICC would have to wait for the Security Council's decision, and only afterwards will the ICC be able to open an investigation. So this is one important thing to bear in mind. Secondly, because this was also mentioned in your question, we need to be precise. We need to make a difference between international liability of a country and criminal liability of an individual. If we're talking about the country's liability for the infringement of the international law, then under classic rules of international law, this liability means compensation. Now, the country cannot be punished. Why not? It's the Roman law that says par imparem non habet imperium. That is, the equal to the equal cannot have power over another equal. So there is no criminal liability for states, but there is criminal liability for people, for individuals. And Professor Kamiński has already described that, and I agree with that. I have two additional short questions. Those of you who are here in the room, and those of you who watch us on YouTube or Facebook, please think about your own questions, because we'll start the discussion with the public in a minute, which is probably the most interesting part for you. And I have one more question. Now, this question for detail is as follows. As far as I understood it, so the Security Council has to state that an act of aggression has happened. But I remember, I'm a historian, that in 1933, a few countries, including Poland and the Soviet Union, actually the Russian Federation is tantamount to it, they signed the London Convention on the specification of an aggressor. And it says that the first country that introduces the army on the territory of the other party, or the country that sends armed groups on the territory of another country, then this country will, by default, recognize as an aggressor. So maybe what we have now, which is binding for some countries, and it's binding for Russia and Ukraine, so maybe this could be applied here. And now the second question, a more general one. A little bit provocative, maybe. I talked to a friend, a lawyer specialized in international law, and international lawyers sometimes have a specific perspective, because she said that Russian prisoners of war are treated in a humiliating way by Ukrainians, because the Ukrainians, they record videos with these scared prisoners of war. They publish these videos on the internet, and hence they break the ban on the humiliating treatment, which is binding under the Geneva Convention. But someone who is not a lawyer might say, well, Ukraine is fighting for its existence as a nation, as a separate state. And it's just a very emotional matter. So just recording these videos is a way to demoralizing the enemy. It might be justified. It could be just justified to prevent the greater evil. And so my question is about the international law system. Maybe it should be reformed. The UN, the Security Council, and certain legal norms. If there is a group of these rogue states that systematically break this international law, we will start the discussion with the public in a minute. Just these two questions first. The floor goes to our guests. Now, we've been talking about this reform of the Security Council for 50 years, because we all know that the United Nations needs to become more effective. And probably the best method would be by reforming the Security Council. But I will just give you an example. In the UN Charter, you can find one provision about unfriendly nations. And this provision says that no provision of this charter can undermine the legality of the measures adopted towards so-called unfriendly states. And these were the allies of the Third Reich during the Second World War. And since 1974, when two German states were accepted to the UN, well, this provision is just empty in the Charter, but it still is in the Charter. Why is that? Because the countries do not agree what to do with it. They are afraid that if any state proposes any kind of reform of the Security Council, then other states will propose another thing. They will have another proposal that had not been discussed before, and maybe this will go through. It's like changing the Polish constitution. We all know that some things should be amended in the constitution. I don't mean that in any political terms. I mean certain technical amendments that will just make it more efficient for a state to function. But no one dares to do that. But this Litvinov's protocol, well, this is intriguing. I believe it might be still in force. But there are no sanctions under this protocol. It's just a definition. And then this definition was then repeated in the UN Charter, not in the Charter itself, but in a resolution from 1974. This was the UN General Assembly's resolution, which is called the definition of aggression. And it's based on exactly the same principles as the Litvinov's protocol. And the first, just generally known, you must have heard about that. The one that shoots first is the aggressor. That's the principle of the first shot. It is to be found in all legal acts on aggression. And so this today's definition of aggression from 1974 was built on that, on these previous definitions. But still, from a formal perspective, it would be easier to rely on the Litvinov's protocol, that is, on the agreement on aggression, because it's binding. At least we know that no implementing executive acts are needed for that. Now, this definition of aggression can only be applied if the Security Council decides that it can.
1933 roku wiąże, prawda?
The agreement of 1933 is binding, however. Of course, this requires to be verified, how it applies to Ukraine and how is it about, taking over the post-Soviet agreements. Just briefly, referring to the second issue. I know who asked that question. That was a person who is really an outstanding expert on the international humanitarian law. In the past, it was the law on war. Now it's called humanitarian law. It specifies the rules for treating the prisoners of war. This is a law, actually, that stems from the beginnings of the 20th century. So there are certain rules on how to treat prisoners of war. So ban on killing the prisoners of war, ban on mistreatment, and humiliating treatment using swear words while addressing prisoners of war. Well, I don't know actually what you refer to exactly in the conversation with your friend. So I'm not sure what exactly actually you're talking about, which words you were disputing about. But at the level of the basic international law that stems from certain conventions like Hague and the others, there are the ways, basic ways how the prisoners of war should be treated. There are certain rules saying that the prisoners of war should not be shown in media. But as far as I saw it, these were not actions undertaken by the state. These were not the images that were disseminated actually by media. So we live in the world which is decentralized when it comes to information. In fact, each of us can record something and then post it on social media, and these materials will be disseminated broader than classical, actually, content of the classical media. So these rules, classical, traditional rules, do not refer to the contemporary technological possibilities. So I don't think that we can say that this was the action by the state. So I would not like to talk to specify whether the state did something wrong or not. Okay, ladies and gentlemen, we have 2, 3, 4 questions. But because of interpretation, we need microphone. Please bear in mind that Przedsiębiorcy magazine. I would like to ask you the question asked by the ambassador of Ukraine in the UN, the question he asked. How it was possible that Russia actually took over the position of the Soviet Union in the Security Council? And another question related to that. The position of General Assembly towards the Security Council. There was one problem solved already, or discussed already. It was about the representation of China, and that was decided by the General Assembly, even though Taiwan representing China did not like it. Even though it was a little bit awkward, they were not able actually to use the right of veto. But US also voted against it because the fact that China was thrown out from the General Assembly was not accepted, and there was no veto on that. So General Assembly in that specific case was actually overriding the decision of Security Council. So I have these two questions. They are somehow related. So, well, let me make an exception. Usually we actually collect some questions, but this question was so important that I would like to ask my colleagues to answer immediately. The first question is pretty easy. At the moment of the collapse of Soviet Union, President Yeltsin became a president, and Yeltsin actually wrote a letter to the Secretary General, and he said that Russian Federation takes over the position of Soviet Union in the UN, in the Security Council. It was quite unusual situation, so to say. But there is another question, actually, to be answered, whether Soviet Union and the Russian Federation, whether it was the same state or not. So if we assume that was the same state, there is no problem. We don't have any problem here. But from the legal perspective, it is the same state indeed. However, how can we decide on that? There were two elements that decided on that. The first one, the permanent participation of Russia in the Security Council. In order to say that the Soviet Union is no longer the member of the Security Council, it would require a revision of the charter. The UN charter would have to be amended. Nobody wanted to go for it. The second element that confirmed the equality of these two states, or maybe let me ask you a brief question. The role of Serbia in former Yugoslavia was quite similar to the role of Russia in the Soviet Union. Why Serbia was not treated as the state identical to Yugoslavia, and Russia was actually treated as Soviet Union? Why? What was the difference? The nuclear weapon. Russia had it, and Serbia did not have it. So the necessity to revise the treaties on nuclear war, that was a decisive factor. So it was quite pragmatic perspective. And Russia actually stayed in their position. Nobody challenged that. That's also quite interesting. International law is deformalized. There are some cases where international law is extremely important. However, there are some decisions taken in informal way, and that was one of them. Of course, I would feel much better if there was a procedure of approval of Russia acceptance in the Security Council. Back then, probably it would be accepted without any question. The question is whether they, in the General Assembly, sorry, the question is whether they would get their place in the Security Council. So that's all about this succession. But nobody challenged, nobody protested against that decision, and that's also quite interesting and important element while shaping this practice of succession. We cannot say that there was any interdependence. It was done, however, in a very tricky way. The letters of ambassador of Taiwan was not actually being the letters of authorization was not being accepted from Taiwan, but they were accepted from the ambassador of China. Just one practical idea. In the context of that specific case, Chinese case, where there is a need for the second Russia that would appear, and his letters of authorization would be accepted. However, it's quite a tricky hypothesis. In the international law, however, this could be a legal solution. We have more questions from the audience. Eva Huska, I have two questions. Ukraine needs its airspace to be closed because all strikes, attacks actually happen from the air, mainly. Who can do it besides UN? Is there any other organization like Council of Europe could go for that decision? Second question, very similar to the first one. Ukraine needs aviation. The old aircrafts were supposed to be given to Ukraine, actually, as weapon, but Ukraine do not have airports, because airports have been bombed. If the aircraft with the Ukrainian pilot, with the Ukrainian flag, actually, but aircraft starting from the territory which is outside Ukraine, how would they be treated? It is a very difficult, actually, question. From the formal perspective, it would be, well, using the principle of proportionality, because we have to remember that principle. Principle of proportionality that, to a certain extent, shapes or makes us interpret in a certain way the ban on force. Definitely, it would be infringement of neutrality. And again, we are coming back to the starting point. The Security Council did not take the decision, and moreover, the procedure was initiated, a procedure of adoption of resolution that would condemn Russia as aggressor. However, this resolution was vetoed. Therefore, United Nations cannot authorize any other state to get involved in the war. I'm afraid, and let me draw your attention to something that was already said by President Biden and Stoltenberg, head of NATO. Neither NATO nor the US nor any other state would become a party to that conflict. That's why I think that Western states will be very careful not to become a party to the conflict with the Russian Federation. That's why it's quite unlikely that the aircrafts that start actually from Poland performs their military actions over Ukraine or Belarus and then return to Poland. This would probably breach the neutrality of NATO states. It would trigger some military actions. Russians would start to defend themselves. Once they defend themselves, they would shoot some of the aircrafts. I'm not sure whether these aircrafts would be Polish or the Ukrainian ones. I understand they should be handed over to Ukraine somehow. By the way, it's a great idea. There was yet another idea to give T-72 tanks to Ukraine, the upgraded, modernized ones, actually, that were at the disposal of the Polish army, and to be replaced by new Abrams. But on top of on the legal premises, there will be these great politics that will decide. And nuclear potential. It's like, it's just coming back to the context of Serbia and Russia to be treated differently as successors. So the case of the aircraft starting from Poland, from Slovakia, Bulgaria. And aircraft that would come back after the military action to the aircrafts in the mentioned states. That would be really problematic. However, it would be just, sending weapon, it's a different case. If we look at the practice, we can find a lot of similar cases. US, before they joined the Second World War, they sent weapon to the UK. Vietnam, war in Vietnam. Of course, all this happened at different level. When it comes to the technique of handing weapon over, that was a different thing. Afghanistan, yet another case that we could refer to. So, in fact, there is a certain area where, from the practical perspective, it could be done, and there is another area that could become quite problematic because it would translate into quite bigger consequences. So any weapon, it comes to Ukraine from many countries. Turkey actually sends to Ukraine very effective drones. So there is an area to do it. And there are cases from the past showing what the practice was and how we can maneuver in a safe way, and when the problems start. Just, okay, so handing over like aircrafts or tanks over to Ukraine to be used in Ukraine, that would be okay. Well, at least, we can come up with the cases that from the past, of similar cases that happened already, and it did not end up in a situation that the given case actually, that the given country were becoming a party to the conflict. So the state, so this does not infringe the right to neutrality. There was we discussed about the aggression, the crime of aggression. In the public debate, we do not use the notion of the crime against peace. It was a Treaty of Nuremberg, actually, that said about, that mentioned about this crime. Hypothetically, it would be used as a tool to, hypothetically, if we actually indict the perpetrators. And maybe talking about the future, bearing in mind everything that happened, something that was unforeseeable, unimaginable, happening, the aggression and war in Europe. Will this situation not create a lack of trust in the security systems? And maybe we will return to the argument of power as a decisive factor, decisive argument, because right now everything will depend on the fact whether Ukraine will defend itself or not. And one more comment. Professor Czapliński said we would need another Russia. Well, bearing in mind what we hear about Siberia, maybe Siberian Republic will replace Russia once.
We have the flags from the Kaliningrad. Okay, so we have another question. Good evening. I have a question to Professor Czapliński. but it's a comment on both of you said. Professor Czapliński at the very beginning said that we are facing a new reality where the international legal order has been questioned. If this is the way that we describe the gist of what is happening and what is worrying everyone, then my question is, how can we look for resolution? How can we prevent this kind of philosophy from developing on the Russian side? Because we have this new semantics appearing. There is sovereignty, but there are also new entities like indivisible security, passportization, attempts being made to allow for incursions that go beyond certain recognized international relations. And now the second question to Professor Czapliński as well is about the Simpsons doctrine in reference to the pact of Briand-Kellogg that Mr. Adamski mentioned. This pact can be read, interpreted as the first successful attempt to get rid of aggression, but this pact lacked sanctions, of course. But the annexation of 3 Baltic states was criticized as early as 1940. So we can say that history goes in circles. And one more comment on the beginnings of this conflict, this war, that is the year 2014. This was the year when Putin justified his aggression. Sometimes he does that because, as we know, at 3:45 a.m. last week, he did not even do that. But in 2014, he did say about the Crimea annexation, he said that this is Novorossiya, that this is the territory regained on the basis of the treaty between the Turkey and the Tsar Russia from 1774. So this was the official version as the basis for acquiring the territory. And so Ukraine was supposed to be an occupying force at all times. I'm very sorry. I would like to stop you that because we have one more question. Okay. Under this treaty, Crimea became independent, and Putin did not mention that. And another very detailed question. During this conflict that is becoming more and more violent, we have cluster ammunition being used. We know that Russia is not a party to the convention, but it's not about the usage of this ammunition itself, but about the consequences. What about the liability for using this cluster ammunition? Okay, thank you. We have one more question. Good evening. Henryk Binkowski. Now, what you're trying to do is very difficult because we are in the midst of a war. So talking about peace, it's quite provocative because Mr. Adamski mentioned the treatment of the prisoners of war. So Professor Czapliński, and I would like to thank you for your intellectual courage because I'm an academic and I used your publications. Thank you for what you've been writing. But when there was a question about Belarus, you commanded on Biden. But if I were a politician, what you said wouldn't be enough. why does Ukraine agree to Belarus being in the middle entity? Because this Belarus should not be this middleman if they are a party to the conflict. Even more so that Russians conduct most of the attacks from the Russian territory. So it was, in a simplified way, you could say that it was just one attack in the media. And one more comment, Professor Jasunowicz, Leśko, many professors, they very clearly say that it is not allowed to show the faces of the prisoners of war in the media. We cannot be so barbarian. The Vice Prime Minister, the Deputy Prime Minister of Ukraine, invited the Red Cross to bury the fallen soldiers, but it is the Ukrainians' task, actually. Thank you very much. I made notes of all these questions, but I can see that you did as well, so I will just give you the floor. Thank you. Could you please repeat your first question? I heard the second one. Now the question is without the microphone. Okay, I just need to look at my notes. It's because my pen is not working. The Simpsons doctrine. That was the second question. And the first one, because you said there were two questions. Would you be so kind as to very briefly repeat the first one? Just one sentence, if you could please repeat that. The Simpsons doctrine was the first one, and the second one was of the consequences of using using cluster ammunition. Thank you. Okay, so I will continue. Maybe you need some time to think. No, I'm fine. I know what I would like to say. Is Belarus a party? They are not a party to peace negotiations. The peace negotiations are taking place between Ukraine and Russia. And Ukraine's stance is pretty wise because they say we can talk anywhere. If these talks will have any positive result, we are ready to go to Moscow. But probably Moscow would not be enough. You would have to go to Ural to find the one that you would like to speak to. Simpson's doctrine. Now, it is very much in force under the UN Charter. Under the UN Charter, it is not allowed to recognize illegal situations. That flows from the Charter itself and from the declarations of the International Law of 1970, and it flows from the article on the international liability of states. So I have absolutely no doubts about that. And now the recognition of both of these republics by Russia, this remains a problem. This has not been raised. However, these two republics were recognized in violation of the international law. And there is no doubt about that. Now, crimes against peace. This is a category that does exist, and you can find it in the ICC and in laws of specific states as well. I will not go I would not like to talk about universal jurisdiction. This is quite a complicated topic, but in many states it is possible to hold liable the perpetrators of crimes against peace. And there is a question of conditions for jurisdiction of a given state, because there are some states who say that our law concerns punishing perpetrators of international crimes, but what is required is that there is a certain connection or link between a given state and the committed crime. So each case should be looked at separately. Now, the use of the cluster ammunition, well, is it banned? Well, it's not always banned, in the sense that if Russia is not bound by the agreement, you could say, well, there's a general ban on the usage of weapons that causes disproportionate suffering. But this is a very delicate area, and there are many doubts surrounding that. And there are definitely now the consequences of the usage of this kind of weapon. Well, the state that uses this kind of weapon is liable and has to pay for that, pay compensation. And this takes up the form of war reparations. And it's reflected in the peace treaty. I think I have answered all the questions. Before I give the floor to Mr. Kamiński, I have a new piece of information. Ukraine referred to the resolution of the General Assembly of the UN, and the Ukrainian parliament asked the UN for the introduction of peace forces on the Ukrainian territory. Professor Kamiński. Ladies and gentlemen, the UN forces have been in many places before. They still are, but it's not the General Assembly's decision. That's the problem. This is not the body that would make the decision. Maybe, yes, but we're talking about international law, which does not operate in a void, but there is politics, there is certain reality, and this will be decisive for how certain international law provisions will be applied or not, or qualified as not applicable. And it's this context that needs to be taken into account. From the formal perspective, this is not the discretion of the body that adopted the resolution. Would you like to add something? Professor Czapliński. There is this UN practice which has a very strange facility of the coalition of the willing, very informal, again, because it's actually outside of the charter, but it gives this possibility to use force, for the force to be used by states for various purposes. But this UN's mandate is always necessary. And I believe that if a permanent member of the Security Council is the aggressor, I do have some doubts whether we would be able to build such a coalition, to form such a coalition. Such a coalition that would mean the division of the fighting parties, because this is how these peace forces work. And all parties of the conflict would need to agree to that if we don't want to run the risk of these peace forces being annihilated. So I would like it to happen very much. But given the state's attitude to the institution, I think it would be very, very difficult indeed. Very briefly, on the things that came up in your questions. Now, the rules of the international humanitarian law, and in which context certain weapons can be used, such as cluster ammunition. Now, Professor Czapliński has already mentioned that. We are dealing with very specialized legal acts to which Russia is not a party. And this is very important when we talk about these international obligations. But despite this restriction, we can still stick to the classics of international law. And this very basic principle is the protection of those who do not participate in the actions. That is the protection of civilians. And if these weapons that are not banned in the areas where civilians live, now the probability that this weapon will affect civilians, this is a convincing argument. But as Professor Czapliński has mentioned, this is a very specific, a very complicated law area, and unambiguous even, I would say. We could also ask questions about the legality of nuclear weapons, and this question has not been settled so far. Ladies and gentlemen, we are shortly running out of time for the discussion, but I have one last question. And maybe this is the question that many of you had. I did as a historian, interested especially in the Second World War. Now, the League of Nations was the president of the UN. Germany attacked Poland, but they withdrew from the League of Nations. And the Soviet Union, when they attacked Finland, they were members of the League of Nations. Formally speaking, the Soviets said that they did not attack Finland, they just helped the government of the Finnish People's Republic. That is the government that they created and stopped themselves, classical example. And so the international community was really furious. And there was a special session of the League of Nations, and they decided to throw away the Soviet Union, and it happens on the 14th of December in 1939. And as I had said at the very beginning, we could say that this war is mainly about Ukrainian independence, the existence of the Ukrainian nation, state. Putin does not recognize the existence of Ukrainians as a separate nation. Only he does accept that only if Ukrainians keep these strong ties with Russia, which is unacceptable, which is not possible in this situation. And what if we throw Russia from the UN?
If I remember well, there is no mechanism for that. I would say that we would then have a big problem to accept the decision that a given country would like to withdraw from the UN. Let me draw attention yet to one aspect. Apparently, the former Prime Minister Medvedev said it was good that we were thrown from the Security Council because we will be able to reintroduce death penalty. I believe that it's better to have a given state within a given organization to have an impact on that, because international organization vis-à-vis external world does not have any capacities to impact them, but it can impact its members. I was asking I asked a question thinking about the protection of the international standards, international laws. Well, using the mechanism that you ask, actually, like throwing away a given state from an organization, is just, not possible. But maybe you did not mention, you did not notice what happens in the Council of Europe. Belarus is not there, but all other states are there, including the Russian Federation that assumed many duties and obligations, and its membership in the Council of Europe is quite problematic. Things that happened on Saturday, the initiation of the procedure. Again, there is no procedure of actually throwing out. It's just, the procedure of asking to leave. So it's about suspension of the capacities of a given state. They have no longer valid votes. They cannot have the representatives in the meetings of the Council of Europe. The Ministry of Foreign Affairs cannot be represented in the Council of Ministers. They simply do not exist anymore. They have been suspended. At the same time, there is a deadline given for them to leave. So the Saturday's decision was quite, so to say, easygoing, because there is no deadline stated. Maybe it will be given still, maybe not. The text of the Statute of Council of Europe is quite clear. Suspension and giving the deadline for the leave of a given state. Professor Czapliński said it's better to have a given state as a member of the organization because it's easier to exert the pressure. Council of Europe as a gentleman's club, it's a very specific organization. It's a very special, similar to the UN. In the UN we have not that many gentlemen, actually, but in the Council of Europe, by the way, is based on democracy, rules of law, protection of human rights, basic rights, basic values. Russia has problems with that. It has also problem with its aggression, infringement of integrity, territorial integrity. Statute of the Council of Europe, as I said, should be made broader on a ban on aggression, infringement of integrity of the territory of other states. So Council of Europe was planned for different states. There is no place for Russia in the Council of Europe. Let me repeat it. There is no place for the Russian Federation in the Council of Europe. It is no longer fulfilling certain criteria, basic criteria. I understand this argument. It was actually raised already, talking about the membership of Russia. The discussion started after the aggression on Crimea. Finally, they decided it's better to have Russia in Strasbourg and the Council of Europe to be able to have an impact on it. But it's not the case. If the Council of Europe is going to be a serious body, then there is no space, no room for such Russia in this gentleman's club. We may be of different opinions, but this regime of membership is strongly related with a certain etiquette. And this country is not following this etiquette. Just, a kind of summary. Yes, summary, exactly. Let's wrap up. I just wanted to ask you for a short summary and maybe some recommendations, short, brief recommendations from lawyers. No, just one sentence to summarize it. But before that, let me refer to the purpose of the Council of Europe. Council of Europe was not to protect the peace on the international arena. Another organization was actually going to assume the military functions. And let me summarize. Who can be a member of the United Nations? The Charter actually gives one condition only. And this is probably the only love condition in the international law. It can be the member of the UN can be any country that loves peace. Let me summarize in the following way. We discussed Russia as a problem, as an issue. I know lawyers in Russia. In the recent days, I've been contacting them on social media. They share our worries and opinions. There are many Russian lawyers who are of the same opinion as we are. They have no doubt who the aggressor is, who infringes the international law, who the real problem is. So let's remember these atypical Russian lawyers. The true Russians, this debate was organized by the Polish-Russian Center for Dialogue and Understanding. Since some time we have not seen any dialogue nor understanding. There is a dialogue, actually, how to hold Putin liable for his actions. It's rather a monologue than a dialogue. There is no reaction to this monologue. Let's hope they would be able to hear these messages that are kind of warnings or indications. Russia, who is opposing, this is not Russia of dissidents. These are Russians that start to protest in some numbers. Maybe this is just a beginning. Of course, they are fought against some, independent media, actually, are closed down. These people, these protesters, even if there are not many of them, they also create a problem. They are an issue to Russia. Ladies and gentlemen, without expectations, we started to talk about the liability or co-liability of Russians for the Putin's regime. Let me say my position, share my position. The moral ostracism is the political weapon. All the Russians who, latest on the 24th of February 2022, did not condemn the crime of aggression to Ukraine, there is nothing to talk about with. These people have to be covered by this political ostracism. People who keep silent should also be condemned, not even mentioning the supporters of Putin. We have to, however, try to influence the media because they can change something. And moral ostracism could be a weapon. Now I would like to thank both professors. I would like to thank our audience, everyone who came to this debate. I would like to thank everyone who followed discussion online. I would like to thank our Ukrainian friends who followed our discussion. We sincerely hope that Ukraine wins, and we will try to help this victory with all our with everything we can do. I would like to also thank interpreters and all the organizers of this debate. Thank you.